Hello. Hi. Welcome, everyone, to what will certainly be a thoughtful and engaging dialogue focusing on the legal aspects of September 11th and the events that have followed. This forum is just one of several opportunities throughout the day to remember and reflect on the events of the past year, the society that we live in, and what we are fighting to protect. We recognize that there are many ways to commemorate this day and to deal with the wide range of related emotions, memories, and questions. In light of this, I wanted to also remind everyone of other events going on at Duke today that are open to our community. In the Duke Chapel, there's an interfaith service at 1 o'clock, followed by organ music at 1:30, Vespers at 5:15, and there's a Catholic Mass tonight at 9 o'clock. At 7 o'clock, in the Public Policy Building just across the street, there will be a symposium featuring our Professor Silliman, as well as professors of public policy, English, and medicine. Throughout the day, of course, students are as always welcome and encouraged to talk to the Office of Student Affairs, to their deans, professors, fellow classmates, and their friends. And with that said, I'll hand this over to Professor Schroeder and our distinguished faculty panel.
Thank you very much. I've been instructed by the powers that be to let you know that this event is being recorded and webcast. So for what that's worth, take it into account. The events of a year ago are on our hearts today and the hearts of people throughout the world. And variously, emotions, memories, as well as thoughts about what the future might hold, vie for places in the foreground of our thoughts at any particular time. Today's event is going to emphasize the forward-looking dimensions of those complex reactions we're having to the events of a year ago. And it grows really out of the distinctive nature of who we are as a law school community, namely a community involved in the enterprise of training people to be this country's future lawyers. I want to read you something that A.P. Carlton, who is currently president of the American Bar Association, sent out yesterday. He, incidentally, was our last commencement speaker last May. And this is an open letter to the profession. I'm not going to read all of it, but just a couple of sentences. He says, "The deep outpouring of grief and sympathy from ordinary people all over the world was the manifestation of an almost universally held belief that despite the disagreements that invariably exist between nations, America is a phenomenon unlike any other in the history of mankind. We are a nation of individualism, fiercely protective of all manners of our freedom, a place where one can believe in any God, speak any idea, maintain any belief. The United States has been a salvation for millions and millions because we are a nation of democracy, tolerance, and the deeply held conviction that the human spirit, left to flower, can triumph over almost any challenge. Such an allegiance to these ideals is not just rhetorical. It is written into and facilitated by our laws. It is our law, above all else, that binds us all to a common moral code. Our law protects us from tyranny, rewards our creativity, punishes our corruptness. Our law facilitates that which is the greatest moral concept our species has ever had the temerity to develop, the concept of justice. I hope all lawyers have felt, as I have, a renewed passion for our chosen profession in these new times. No matter how far removed from your daily work, no matter how far removed your daily work seems from the founding principles of this nation, we know that it is not. So, in the spirit of Mr. Carlton's remarks, we're going to spend some time today just touching on 3 or 4 of the key legal questions that have emerged in the past year and that show every indication of being significant issues of public debate as we move forward. This event is not meant to be exhaustive by any means, and we'll be having a series of similar workshops and fora throughout the semester, just as we did last year throughout the year, and I invite you to attend all of those and to feel free to discuss with any of us on the panel or other members of the faculty. There are a number of other people on the faculty who have devoted energy to thinking through the legal issues involved in various dimensions of the war on terrorism, who I'm sure will be generous with their time. Today, we're going to hear from Professor Michael Byers, Professor Madeline Morris, and Professor Scott Silliman, each one of them, as I say, taking up a relatively discrete aspect of the emerging legal issues and legal description of the war on terrorism that has seemed to be at least one of the questions of prime significance in areas in which they work. So we're going to proceed rather informally. People will feel free to speak here seated or come to the podium. We're going to speak each for about 10 minutes and then open the floor for questions on points that have been discussed or points that haven't been discussed. I'm going to moderate and exercise the moderator's prerogative of adding a few remarks at the very end. So, Professor Byers.
Well, I was in a small English village south of Oxford a year ago, and I remember on what was there the afternoon of September 11th, watching with my wife the two towers in New York fall down. And for us, it was very clear that this was not only an attack on the United States, but an attack on the entire world. And through the horror of that afternoon, part of my brain, a small part of my brain, was still acting as an international lawyer and reminding me, driving home the point, that international law post-September 11th would never be the same, that something that big could not happen without changing my field. I have been writing specifically on issues concerning the use of military force and international law for the last 2 or 3 years. And it's that area of international law that I want to talk about today. The United States was quite clearly going to attack Al-Qaeda and the Taliban in Afghanistan, regardless of what international law said. But it was quite clear to diplomats and lawyers in the US government that they would do so more effectively if they could carry a large number of allies with them. And those allies wanted the military action to be justified under international law. Now, as it happens, there were 4 possible justifications for the intervention in Afghanistan. First, one could have argued that the intervention was invited by the legitimate government of Afghanistan, i.e., the Northern Alliance. Secondly, one could have argued that the intervention was an act of humanitarian intervention, freeing the oppressed and starving people of Afghanistan from a grossly irresponsible government. Thirdly, the United States could have gone to the United Nations Security Council and requested an explicit authorization for the military action under Chapter 7 of the United Nations Charter. There's no doubt in my mind that had the US asked for such a resolution, the vote in favor of that resolution would have been 15-0. Such was the sympathy for the United States and the worldwide concern about the threat from terrorism. But the United States chose instead to focus on a 4th justification, the right of self-defense, which is set out as an exception to the rules governing the use of force in the United Nations Charter. In Article 51, the inherent right of individual or collective self-defense is preserved if an armed attack occurs against a member of the United Nations. Now, prior to September 11th, 2001, there was some question as to whether terrorist acts could constitute an armed attack, justifying the use of force against the territory of another sovereign country. That question was resolved in the few weeks following September 11th because the United States made the claim that this did constitute an armed attack, that there was a right of self-defense against the Taliban, and the international community of nation-states fell behind the United States, explicitly or tacitly agreeing with that claim. My view is that the international law concerning self-defense was modified just slightly as a result of that widespread support for the United States' action. And because of my conclusion on that, it follows that I think that the removal of the Taliban was entirely legal. At the moment, there is a similar but different legal issue on the table. And this is the question of Iraq, and whether or not the United States has the right under international law to attack Iraq in advance of any attack by Iraq on the United States. Now, Article 51 of the UN Charter, which I've already referred to, says that the right of self-defense exists if an armed attack occurs. Now, many international lawyers have interpreted that phrase as precluding any right of preemptive military action. Some international lawyers argue that the inherent aspect of customary international law in Article 51 means that a pre-existing right of self-defense against an imminent threat has survived the constraints of Article 51 as introduced in 1945. But it's quite clear that even if you accept that there's a limited right of self-defense against an imminent threat, that what President Bush and Vice President Cheney have been claiming for the last month goes beyond that. They are advancing essentially a right of precautionary action against at least some kinds of threats, i.e. threats from weapons of mass destruction. They're advancing a claim that, if widely accepted by other countries, might change international law. But at the moment, it's difficult to argue that that claim is consistent with existing international law. Now, this is absolutely crucial. Not because the president will stop any attack on Iraq if he's worried that it might violate international law, but because it determines whether the United States' traditional allies will support the United States in any such action. And there has been a huge controversy in international affairs the last couple of months over this particular issue. So, for instance, you have Jacques Chirac, the French president, saying that any preemptive action would be a violation of the UN Charter. Gerhard Schroeder, the German chancellor, saying the exact same thing. Many of the states in the Middle East stating that they would deny the use of their territory as forward staging positions for a unilateral preemptive attack because it would violate international law. And caught in the middle of this debate, Bush and Cheney on one side arguing for a wide right of preemptive action, many of the allies in Europe and the Middle East on the other side saying that no preemptive action is allowed. There's a small group of countries, namely my country, Canada, and the United Kingdom, or at least parts of the United Kingdom, the Foreign Ministry, saying that there is a very limited right of preemptive action, but show us the evidence that there's an imminent threat. Now, over the last couple of days, it seems that there's been some movement. It seems that wise counsel from other countries have managed to convince the president that tomorrow, when he speaks to the United Nations General Assembly in New York, that he should ask for the United Nations Security Council to give a clear resolution in support of action against Iraq, probably contingent on one last chance for Iraq to allow in full weapons inspections. Now, if President Bush does that, if he goes to the Security Council tomorrow and gets an explicit Security Council resolution, then any attack on Iraq would be legal. It would also, in my view, be very good for the international community, especially in the war against terrorism, because we don't need to have this fragmentation of support. If weapons of mass destruction in the hands of Saddam Hussein and there is evidence that he has these to use them, then I myself have no doubt but that the 15 members of the Security Council will come behind the United States and take collective action to deal with that. To go it alone would be to fragment that consensus and that support. The president might well wish to remember the action that his father took in 1990 after Kuwait was invaded by Iraq. At that particular time, the United States could have removed Iraq from Kuwait without a Security Council resolution because of the collective right of self-defense of Kuwait, which would have invited support and assistance from the US. But George Bush Sr., very wisely, decided to go to the Security Council instead, not because he needed the legality of that mechanism, but because he needed the legitimacy of that mechanism. It's that model that I think the current president should follow, and my hope is that tomorrow that's exactly what he will do. Thank you.
As Professor Schroeder has said, we're going to be taking somewhat discrete issues, all related, of course, to the issue of international terrorism and the events of 1 year ago today. I'm going to talk about the relationship between terrorism as a crime and jurisdiction. In particular, I want to consider with you the major issues and tensions that will ultimately determine how crimes of terrorism will be handled within the arena of international criminal law enforcement. Because terrorism sits at the cusp of crime, politics, and international relations, it turns out that the question of whether we should conceptualize attacks that are terrorist attacks as crimes, and if so, how we should deal with criminal law enforcement over this peculiar sort of crime, turns out to be a complex question. Most crime, as you know, is prosecuted domestically. It's prosecuted in national and not international courts. And that's true even of cross-border crime. States criminalize conduct at the domestic level, and by states, of course, I mean nation states, countries. And where states need to cooperate with each other in the enforcement of their criminal law, they do so. States provide other states with evidence that's located outside of the prosecuting state. They extradite suspects to each other, and so on. That's how that's how criminal law enforcement ordinarily is handled. But then terrorism is not an ordinary crime. It's not even a form of ordinary cross-border crime. In fact, there is no such crime as terrorism internationally. That is, although the term terrorism has no international legal definition, the term nevertheless has some indications and would seem to indicate at a minimum some violent act, unlawful, and committed for political purposes of some type. Unsurprisingly, since terrorism has political motives, states are typically the targets and not infrequently the sponsors of terrorist acts. That fact makes the subject of criminal jurisdiction over terrorism a much more complicated issue than would otherwise be the case. Because of the likely involvement of states as targets or sponsors of terrorism, there's an impetus to resort to some authority above the state for the handling of terrorist offenses. And it's easy to understand this impulse if to seek an authority above the state, where the alternative would be to rely upon the very states that may have sponsored a terrorist act to enforce the law against that act. Obviously, if that's the alternative, we can see the impetus and the reason for attempting to go a level higher to resort to some authority that is supranational, that is above the authority of states. So we can take, for example, the bombing of Pan Am Flight 103, the flight that exploded over Lockerbie, Scotland. There's evidence that that bombing was in fact sponsored by the government of Libya. Now, there's an international treaty, the Montreal Convention, that criminalizes and provides for the prosecution of aircraft bombing. Libya, the UK, and the US, as well as other states, are all parties to that treaty. And the treaty provides that whenever an individual suspected of aircraft sabotage is found on the territory of a state that's a party to that treaty, that state must, at its discretion, either prosecute the suspects or extradite them for prosecution elsewhere. The two suspects in the Lockerbie case were Libyan nationals living in Libya, and Libya said, we'll prosecute them in our own national courts. Now, since there's evidence that Libya was in fact the sponsor of the bombing, this is a problem. The UK and the US insisted that Libya not prosecute the suspects domestically, but rather extradite them to the US or the UK for prosecution. And this, Libya, unsurprisingly, did not comply, and eventually the issue was presented to the UN Security Council, and based on the evidence that Libya itself was implicated in the crime, the Security Council issued a resolution effectively requiring the extradition of the two suspects. Now, Libya claims that the Security Council had no lawful authority to issue that resolution. And this dispute between Libya, the US, the UK, and the Security Council, although it wasn't framed as being a dispute with the Security Council, but this dispute resulted in a lawsuit brought by Libya that's still pending before the International Court of Justice. At the base of that dispute is the set of legal problems that's posed by state sponsorship of terrorism. Libya, which would ordinarily be responsible, even under the Montreal Convention, for the enforcement of the law against aircraft sabotage, can hardly be relied upon for that purpose if the government of Libya is in fact responsible for the crimes. So the solution to the problem of state involvement, and in this instance, state sponsorship of terrorism, in the Lockerbie case, was to resort to an authority above the state. In this instance, that authority above the state was the United Nations Security Council, acting under its special powers afforded to it under the UN Charter. So that's an example that illustrates why it's fairly easy to understand the impulse to internationalize law enforcement, in this case through the authority of the UN Security Council, where the state that would otherwise exercise jurisdiction is itself implicated in the crime. It's somewhat less easy to understand, however, the impulse to internationalize law enforcement where the state that would otherwise exercise jurisdiction is not the perpetrator state, but rather the state that was the target or victim of the terrorist crime. So we can then come back to the events of a year ago and ask why it was then that when the United States suffered terrorist attacks a year ago today, there were suggestions and a very serious debate about whether prosecutions should be conducted outside of the United States courts, in third-party states, or in an international tribunal. In a way, the reasoning in support of the suggestion for an internationalization of the prosecutions, in a way that reasoning was analogous to that in the Libya Lockerbie case. The US was viewed, in effect, as a party to the conflict. The courts of the United States, it was said, could not be relied upon to be neutral, or in any case, they might be perceived to be non-neutral. Therefore, the case, some argued, should be handled by an outside authority, and preferably one that's in effect higher than a state, an international court. So we can understand, even though it's not really analogous, and certainly not analogous in every sense, the analogy that's drawn in terms of whether it's a perpetrator state or indeed a target state, the idea that these are political crimes which then implicate the very states that would prosecute, be they perpetrator or target states, as in some sense a party to the dispute, as it were. The impulse to internationalize justice processes in this area is in that sense an understandable and maybe even a logical response to this recognition that crimes of terrorism have a political component and, where it's international terrorism, an international political component. And so the reasoning would be that states are interested parties and as such can't be permitted to stand in essence as judges in their own causes. Internationalization of justice in this field might be a tidy solution to this problem if there were an international institution or institutions that states trusted sufficiently to decide these matters. The problem is that we don't consistently find that kind of confidence placed in international institutions. Certainly Libya challenged the authority of the Security Council in its case, and the US, acting in radically different circumstances to be sure, declined any suggestion of an international tribunal for prosecution of the crimes of September 11th. Precisely because terrorist crimes do have a volatile political and foreign relations dimension, states are particularly wary of relinquishing control over these cases to international bodies. This is by no means a settled field, and we're going to see development of the contours of national and international authority over law enforcement in the field of terrorism in the near future. The new Permanent International Criminal Court, which is coming into existence literally as we speak, is planning to take up the question whether its jurisdiction should be expanded to encompass crimes of terrorism. And of course, the Lockerbie case is still pending before the International Court of Justice. As the developments in this field unfold, as they will in the coming months, a critical issue that I think is really going to be driving and shaping the developments in this field is going to be this tension between, on the one hand, the impulse to internationalize anti-terrorism enforcement based on the logic that I've just played out, and on the other hand, the impulse of states, also quite understandable, to retain control over the handling of these crimes that have such powerful implications for international relations and, in turn, for domestic security. That's what I see as the sort of big picture in terms of the international criminal handling of crimes of this particular sort. I thought when we talked about speaking with you today, I thought about going through the treaties and seeing what the requirements were and what the hooks would be, but in fact decided that the more important and more appropriate picture to convey to you is the one that I hope I have of these sort of competing needs for, on the one hand, some internationalization, the logic behind sort of having some authority, at least outside of implicated states, at least for sponsors, if not for targets. But on the other hand, the motives that states quite reasonably have for wanting to retain control over disputes where states are not necessarily all similarly situated. This is not a unitary international community politically. We know that very well. And for that reason, states may have very different views, and indeed do have very different views, which we can talk about the appropriate definitions as well as responses to terrorist crimes. I'll leave it there. Thank you.
It was said this morning in our courtyard at about 8:35, as I recall, that each one of us should be striving to look for something positive. Something positive that's happened since a year ago today, when many of us met in this room and talked about the issues and the horror that we all felt and the rage that needed to be vented. Professor Byers, in his comments, suggested that, in his view, there is a positive movement by the current administration towards going to the Security Council and to reconcile the American position with what he considers traditional international law. I wish that in my comments I could find something positive, but I must share I do not. Because I want to talk to you this morning about those who are in captivity, those who are facing charges of terrorism. And let me remind you that they are in three categories. First of all, we have Zachariah Moussaoui, we have Richard Reed, the shoe bomber, we had John Walker Lind. They are in our traditional criminal justice system facing trials in our federal courts, charged with violations of United States statutes. Then you have an interesting situation in Yasser Hamdi and Jose Padilla. Now, you may not know who these two gentlemen are, but let me tell you. Yasser Hamdi is a Saudi who was born in Louisiana. He was captured in the same prison uprising in Afghanistan where John Walker Lind was captured. He was initially taken to Guantanamo Bay, and I'll talk about Guantanamo Bay in a minute. But then when his claim that he was born in Louisiana surfaced and the Department of Justice gave it consideration, he was moved to a naval facility in Norfolk, Virginia, where he is today. He has not had access to an attorney. And the Department of Defense, speaking through the Secretary of Defense, has indicated that he probably will never face charges. Jose Padilla, an American, was arrested at Chicago's O'Hare Airport on the 8th of May of this year. And as you may recall, the Attorney General, John Ashcroft, in a very unusual news briefing all the way from Moscow, claimed that Jose Padilla had come to this country to actually set off a dirty bomb. Jose Padilla was kept under a material witness warrant in New York for 29 plus days. And on the eve of the hearing in federal district court to determine whether he should be charged or continued on a material witness warrant, the President of the United States declared him to be an enemy combatant, and he was shipped and placed under military control at a naval brig in Charleston, South Carolina. Now, I point out these two cases because they should raise the specter for us and give us pause concerning the fact that we have two American citizens being treated as American citizens, that no matter how horrendous their conduct may allege to be, they are nonetheless being held in military control without access to counsel and with the prospect of never being charged. And the administration tells us that they may be kept in that confinement until the termination of the war of hostilities, whenever that is. That is a disturbing prospect for me. And I would remind you that we have a statute, as I recall, it's 8 U.S. Code 4001, that says that no American citizen can be detained in this country but for an act of Congress. And I have not found an act of Congress that gives the administration the authority to keep those two gentlemen in confinement. But let me move on to the third category, because that's really where I want to focus with you. And I guess I could paraphrase it as, how does one win an all-expense-paid trip to Guantanamo Bay? We have hundreds of folks down there, many of them captured on the battlefields of Afghanistan, many seized elsewhere. We really don't know exactly who they are. They are considered to be by the administration battlefield detainees, and they are being kept down there. But we must ask, what is their status under the law? What is their status under the law? Are they, as it's been suggested, prisoners of war? And I would suggest to you that that decision is extremely important. Because if, in fact, they are prisoners of war, they are entitled to all the panoply of benefits under the Third Geneva Convention, including, I might add, Article 102, which says they may not be prosecuted by any other type of court except by the type of court utilized by the detaining power. And folks, that's not a military commission, that's a military courts-martial with inherently greater due process than what we're dealing with in military commissions. A military court-martial bears much of the hallmarks of due process of a trial in the federal district court. And I practiced in that arena for 25 years, and I will tell you that as a certainty. Are they prisoners of war? We must look to the 4th article of the Geneva Convention to decide. And that article sets forth different categories of individuals who, if they fall within those categories, are to be considered prisoners of war and extended the benefits of the convention. And there are 3 that pertain to this situation. The first is members of the armed forces of a party to the conflict. The administration says that does not apply because the Taliban and the Al-Qaeda are not members of a party recognized by the United States. We never did recognize the Taliban government. Pakistan did, we did not. Much of the world and the United Nations did not. That does not apply. The second part of Article 4 talks in terms of partisans, those accompanying the forces. But it is the third that has the greatest interest for me. The third says that members of regular armed forces who profess allegiance to a government of an authority not recognized by the detaining power, and certainly the Taliban fits into that category. So are those folks in Guantanamo Bay, do they fall within that category? The President of the United States on the 7th of February of this year said no. And although he proclaimed that the Geneva Convention applies to the conflict in Afghanistan, he said neither any member of Al-Qaeda nor the Taliban satisfy the requirements of the convention. It's an unusual interpretation. The convention applies, but nobody in captivity satisfies the requirement. What are the requirements to be a member of an armed force? They are fourfold, and they go all the way back to the 1907 Hague resolutions, as a matter of fact, the Hague Declarations. It's one, you must be in some kind of a vertical command relationship answerable to someone in authority. Secondly, you must carry your arms openly. Thirdly, you must have some distinctive sign, not necessarily a uniform, but a distinctive sign which separates you from a civilian. And most importantly, fourthly, you must conduct your military operations in accordance with the law of war. Now, I would totally agree with the President. A member of Al-Qaeda clearly falls outside those readings. Why? Because Al-Qaeda, even as we saw a tape, even yesterday and today being broadcast on Al Jazeera, Al-Qaeda has claimed public responsibility for World Trade Center and Pentagon, which intentionally targeted civilians. But I think the problem is more muddled when you deal with the Taliban. I can conceive of some young man who comes late to the fray, who satisfies all the requirements, including his conception of complying with the law of armed conflict. Well, what do you do in that case? The President has said it doesn't apply. The convention itself gives us a mechanism. It's Article 5. Article 5 of the convention says that when an individual is turned over to a detaining power, they are presumed to be prisoners of war and should enjoy the benefits. If in doubt, says Article 5, what do? You convene a competent tribunal. A competent tribunal. That's not a military commission. A competent tribunal, a screening commission. The United States used this in the Persian Gulf War of 1990 and 91 to determine who is and who's not a POW. Our own service regulations only require three officers, one of whom must be field grade, major or above, to sit and make the determination. There's no appeal. I would suggest that 1 week's time, tribunals could meet and resolve all the questions. But we have not done that. The United States has refused, even as against tremendous pressure from our allies, to conduct these tribunals. That is disturbing. Even if the convention doesn't apply, I would suggest that the International Covenant on Civil and Political Rights has some provisions that do. Articles 9 and 14 have specific provisions regarding how long an individual can be detained without any access to an authority who can review and supervise the continued detention. And even though Article 4 of the International Covenant of Civil and Political Rights does say that a country in times of national crisis can derogate from those, it requires that country to notify the United Nations and its other allies through the Security Council and the Secretary General. The United States has not done that. We have not opted to make use of Article 4. if in fact we ever intend to prosecute those folks at Guantanamo Bay, where will that take place? Professor Morris has talked in terms of an international tribunal, this a possibility. Zachariah Moussaoui and others are in our national courts. Any country would have jurisdiction to do it. The option chosen for those in Guantanamo Bay has been the military commission. And let me finish up with a few comments on that. A military commission, in the cleanest sense of the term, is a creature of international law, not of statute. Not of statute. A military commander has always had the authority under customary international law to prosecute members of the enemy and members of his own force for violations of the law of war. That is the sole province of a military commission, violations of the law of war. The United States Supreme Court has sanctioned military commissions in several cases. It was discussed in the Milligan case of 1866. It was sanctioned in the Kieran case involving the German saboteurs in World War II in 1942. And it was specifically addressed several years later in a Supreme Court case called Madsen versus Kinsella, where the Supreme Court clearly said the president in and of himself has the authority to convene these commissions, even quite apart from any action by Congress. The president, on the 13th of March of last year, authorized by a military order, not an executive order, a military order, the convening of military commissions. None has yet been convened. On the 21st of March of this year, the Secretary of Defense issued regulations that would apply as far as the procedure of military commissions, and in my personal opinion, those regulations give us a very high level of due process to military commissions, but for the possible question of appellate review, which is left unresolved. Will there be Article III court review of military commissions when and if we have them? That depends on where they are held, in my judgment. If they are held in this country, then the Kieran case, the Yamashita case clearly say the United States Supreme Court can review a denial of habeas corpus. And that was done in each case. However, an interesting case from 1950 called Johnson versus Eisentrager, which has been cited as controlling authority by 2 federal district courts who within the last 3 months have ruled on this, says that when you're dealing with individuals, non-resident aliens who are prosecuted outside this country, who are incarcerated outside this country, then there is no nexus whatsoever for review in our federal courts. Johnson versus Eisentrager, 1950. So, where will we have commissions if we have them? Why are we building and enlarging the facilities at Guantanamo Bay, which is in Cuba, which is in Cuban sovereign territory? I suspect that's where we'll find them. I am troubled, though. I am troubled by our continual refusal to adhere to the Geneva Convention, even as far as Article 5 is concerned, and I am troubled with the prospects that are evidenced in the images of Padilla and Hamdi languishing in jail without ever having access to counsel or charges made against them.
Thanks to you all. Let me open it at this point for questions or comments from you. Yes.
I have a question for Madeline. You mentioned an international criminal court. You said it's being created as we speak. And then you said one of the issues would be whether its jurisdiction included terrorism. What would its jurisdiction be if it didn't include terrorism? What kind of things?
It's as constituted, the International Criminal Court will have jurisdiction over its subject matter jurisdiction without getting into its in personam jurisdiction. Its subject matter jurisdiction would be genocide, war crimes, crimes against humanity. Which, I mean, whether particular crimes of terrorism constitute crimes against humanity is an additional question.
Yes, ma'am.
For Professor Byers, what is the legal basis for a collective attack in alliance with a victim of an armed attack under Article 51?
Article 51 specifically states that the right of self-defense is not only individual but also collective. And this is why we have defensive alliances such as the North Atlantic Treaty Organization, whereby an attack on one is considered an attack on all. the response of all to an attack on, let's say, Germany would be consistent with the collective self-defense aspect of Article 51.
Jerome?
Scott, could you say something about why you think the U.S. government made a distinction between John Walker Lynn and Hamdi? Does it have anything to do with racial politics, either real or perceived in the country? And why Haya has also been treated outside the normal sort of realm? I don't know whether you have any sort of views on that.
I wish I could suggest that the administration had a clear policy that was set forth before all this unfolded. My suspicion is that the administration has taken an ad hoc approach. I don't think they anticipated that we would ever encounter Americans in the battle. When the original military order was published back in November, this is before John Walker Lind and Hamdi were captured. They were not captured until the end of November. You know that the military order specifically says it does not apply to United States citizens, only applies to non-citizens. When Walker Lind was captured, it sent a ripple, not only through the media but through the administration. How do we deal with this individual? Theoretically, the president could have changed his military order of 13 November to have allowed for the prosecution by military tribunal of an American citizen, but he had put so much political capital into it, selling it in Congress, that I think was politically unpalatable to him. So he had the choice of trial in the federal district courts, which is the option taken. I don't think that would have been the first one they would have wanted to do. I think Zechariah Moussaoui would have been their logical choice to be the very first trial, because you've got, let's be honest, you've got to win your first trial. You can't lose your first terrorism trial. Then when Hamdi came out, again, he was first done in Guantanamo Bay. And to my knowledge, the Justice Department, Chris, maybe you can help me, the Justice Department has never formally said he's an American citizen. That question, he's being treated as an American citizen, but I think it's still under consideration. They had to get him out of Guantanamo Bay for this reason. The government has refused every possible overture in our courts to inquire into the status of those in Guantanamo Bay. If you have an American down there, that gives you a legitimate predicate for habeas corpus. You see, under Johnson versus Eisenhower. So they had to move him out. They moved him to Norfolk, which by no coincidence is within the 4th District, the most conservative one we've got, 4th Circuit. I think they do not know what to do with Hamdi. As you know, his case is now in litigation. Judge Dumar is very actively pressing the government to explain why he can be considered an enemy combatant, the same as being done in the 2nd Circuit with Padilla. I think the government got itself into this box simply because it did not have a specific plan for dealing with different categories of individuals. And the folks at Guantanamo Bay, remember when we talk about military commissions, if they are to be held, they must have specific charges brought against them. And my guess is, Jerome, that the intelligence being derived from the folks at Guantanamo Bay may be good as far as preventing future attacks, but absolutely abominable as far as getting evidence that can be used against them in trial. So we may never have a military commission down there, but that's even more troubling because I don't think we should be able to hold those folks ad infinitum. Let me ask the question directly. I do not see an intent to draw racial differences. I see it more as a question of a confusing plan that is ad hoc.
And I think you're right about the Justice Department not yet conceding the citizenship of, or stating affirmatively that Hamdi's a citizen. My understanding is that there are those in the administration mulling theories through which citizens can repudiate their citizenship, including some that want to insist that participating with al-Qaeda provides you such a ground for argument. So they don't want to be in a position of having acknowledged that somebody is a citizen. They want to leave that issue in abeyance until they see some reason to have to litigate it or come clean on it.
And on that point, we need to be clear that even though your passport may say that you can lose citizenship, by signing up and serving in an army against the United States, when you look at the supporting statute, it's not quite that simple. Yeah. You must serve in that serve in that army with the intent to relinquish citizenship, which is quite a bit different than just the act itself. So it's not an easy concept.
Yeah. Yes, sir.
If the United States is to, or the president is to seek congressional authorization for his, for the use of force, what should this this resolution look like in considering the authorization for use of force involved in Iraq, the authorization for use of force in the terrorism from 2001, and perhaps the Gulf of Tonkin resolution in 1946. If you look at these three resolutions, you'll see five components that perhaps would be useful in a resolution by Congress. One of them being referred to Security Council resolutions, like 678, pointing to the Iraqi authorization. An exhaustion of diplomatic or peaceful remedies was part of that. They made reference to self-defense. Maybe perhaps Congress could refer to anticipatory self-defense or the right to self-defense. It also mentions the War Powers Act and how this was a specific statutory authorization fulfilling the requirements of the War Powers Act. And the Gulf of Tonkin resolution included an expiration of the resolution clause that talked about whether the president could determine or Congress through a new resolution could determine that they didn't need, that this resolution by Congress was over. Do you think that these components could play an important role in any type of authorization that Congress could have? And I guess, Silliman, you'd be probably most apropos to answer this, but Professor Byers and Morris, I'd like to hear from you as well.
If, in fact, the administration goes to the Security Council and does receive some kind of resolution, my own thought, it will be the French model of requiring Saddam Hussein to allow to readmit the inspectors. If he does not within 3 weeks, then the council may meet yet again in authorized force. And that is the model of 678. That is the model. If you look back, and as you probably have, Ron, I'm sure you looked at 678, in November of 1990, the Security Council basically said, unless Saddam Hussein removes his forces from Kuwait by the 15th of January of 1991, then the member states are authorized to use all necessary force. And it didn't take a rocket scientist to figure out when we were going to start flying against him. Bad weather kept us out for a couple of hours, but we nonetheless were there on the 16th. That would be the model, I would suspect, that would be used as the basis for a congressional resolution. Now, interestingly, Professor Byers mentioned self-defense, anticipatory self-defense. I'm of the view that if the United States does in fact say that quite apart from Security Council resolution, it has the independent right to go against Iraq in self-defense, and I do not think the threat is yet clear and demonstrable, but if it makes that argument, then the follow-on argument is that the President of the United States, under Article 2, clearly has the defense to repel attacks and to act in self-defense. So if you use that theory of self-defense, the President can in fact authorize the use of force quite apart from any congressional act. I think as a matter of prudence, what we're doing is we're seeing him go to Congress. He's not saying he's legally bound to do so. No president has ever agreed with the constitutionality of the War Powers Resolution. So I think out of prudence, he's going to approach the Congress. He's already doing that now. There's going to be a debate on the use of force. But, Ronnie, it will make a significant difference on whether we're having, under international law, a Security Council resolution as the foundation, or if we're arguing on this very, very tenuous concept of preventive self-defense, which Professor Byers talked about.
Yeah, go ahead, Mike.
It was interesting that your question was, what should the resolution look like? Which enables me to talk a little bit about the policy of approaching this issue. It's important to remember that the United Nations is very much the creation of the United States. It was negotiated at Dumbarton Oaks and San Francisco. It has its headquarters in New York City. The largest funder of the UN is the United States. The United Nations has consistently served the interests of the U.S. That's why its headquarters are still in New York. So at an institutional national interest sort of way, it makes a lot of sense to use the UN when you can and when it's clearly available, as it is here. Secondly, this issue of preemptive self-defense, what's good for the goose is good for the gander in international law. It operates reciprocally as a system. And I personally think it's very short-sighted to seek to create a rule that would be available to China with respect to Taiwan, that would be available by India with respect to Pakistan. How are we going to constrain the actions of other countries in the future when they say that they are acting against a developing threat? They haven't been attacked yet. But on the precedent of the action against Iraq in the fall of 2002, they're simply doing what the United States did and acting in preemptive self-defense. So on a policy level, what should the congressional resolution look like? Well, the congressional resolution should, as Scott just said, follow on from a Security Council resolution that says, at the insistence and request of the United States, we are engaging the Council, providing an unequivocal Security Council resolution, and implementing a mechanism that for 57 years has worked for the United States.
Take one more. Yep.
My question is, given the fact that the President had authorization in the 1991 Act of Congress that was pursuant to implementing several, 2 or 3 UN resolutions to make war against Iraq for the purpose of liberating Kuwait, and then when that happened, I don't remember at the time that there was a serious debate whether or not it was permissible to take out Hussein incidental to that purpose. I mean, maybe there was, but I don't remember it being a huge debate. I guess my question is given the fact that Iraq has violated the terms of the surrender in a serious fashion, has not allowed these weapons back repeatedly to come in, I think has also fired at Allied planes, which may, I'm also concerned that raises kind of a self-defense possibility, but clearly they have not allowed weapons inspectors to come in. Is it possible just to say, well, the terms of the surrender have been violated, or resumption of hostilities can occur, and so therefore there's no need for Congress to act again because the authorization follows from 91. In a sense, maybe hostilities have never completely ended because you have the fly zone incidents that have happened there. And wouldn't it be the place of the President to interpret to what degree there has been a violation of surrender terms because the executive branch, the generals up there, negotiating with the Iraqis to determine terms of surrender, shouldn't that get some weight as that? And then I guess my question is, why can't the water rise to the level that it was before?
Well, there are lawyers, including my colleague and friend Ruth Wedgwood at Yale Law School, who run the argument that you've just outlined, that because Saddam Hussein is in blatant violation of Resolution 687, the ceasefire resolution from 1991, that the United States and its allies have the right to enforce those resolutions. The problem with the argument, though, is that the concluding paragraph of Resolution 687, which imposes a ceasefire not only on Iraq but also on the coalition, says that the Security Council remains seized of the matter and that it alone will decide what further measures should be taken. Now, as a question of legal interpretation, the answer is clear. The Council alone is competent to rule on whether further military action is possible. But also as a question of policy, that's important. Because what if Iran or Turkey or Israel decides that Saddam Hussein is in violation of 687? Can they take unilateral action to punish him for his violations? The point is very important. Even though the United States is by far the most powerful country in the world, international stability depends on recognizing that the mechanisms that exist apply to it as well, because that's the only way that you can control other countries that are not so powerful and might occasionally have interests which diverge from that of the United States. So again, Resolution 687, despite the creative lawyering that you sometimes hear from people like Ruth Wedgwood, prohibits the U.S. from taking any action apart from a new resolution perhaps to be adopted later this week.
Let me just add one to that. I totally agree with Professor Byers. And I think your question mentioned 678, which was the last of the 12, as being open-ended. That's really not the case when you read 678, because 678, as well as all the preceding 11 resolutions, have this last statement that the Security Council remains seized of the matter. And when you look at that as an interpretive tool, you will see that the Security Council retains control of the situation. As to the no-fly zones, contrary to what you may believe, there is no Security Council predicate for the no-fly zones. When you look at 687 and when you look at the next one, 688, you will find that the only thing the Security Council did was to say that there should be no repression of the Kurds to the north and the Shiites to the south, and 688 actually authorized humanitarian efforts. Humanitarian. There's no mention of use of force. The no-fly zones were established in 1991, late 1991, by the Americans and the British and the French, basically by our own fiat, because we were going to get great intelligence from them. But to try to build upon him firing at American or British jets in the no-fly zones as then a predicate for self-defense rests on that same faulty argument that we've been talking about, that when you actually look at the Security Council resolutions, you will not find what you think is there.
Let me first thank you all for coming, and then ask you to join with me in thanking the panel for the presentations. And we are adjourned until the next time.